This is the American Law Journal.
Every family law attorney involved in a custody battle has heard a client say, "My ex is crazy." Now, what if those allegations actually turn out to have a ring of truth to them? Good evening. This is the American Law Journal. I'm Christopher Naughton. How does the law handle the abusive, the addicted, the mentally unstable ex? And what if both parents are suspect? Gina Passarella with the Legal Intelligencer has this.
Charlie? You okay?
Why do you ask?
Because you're passed out on the stairs.
Oh, that's not good.
How much did you have to drink last night?
Charlie Sheen, poster boy for out-of-control, drug-fueled, unpredictable behavior.
I don't know.
The thing about hypomanics is they don't believe they have a problem. They believe you're the problem, and it sort of begs no alternative. They're very difficult to treat.
And now on his fifth family law attorney, facing yet another custody battle, this time with ex Brooke Mueller over their two kids, as she herself steps out of rehab.
Well, you know, I tell people that a lot of what happens in a divorce case is based on what I call the psychology of the moment.
The clients are constantly in court fighting. I think that takes a big toll on the children.
So what's a court to do when both parents are suspect?
So in cases where there's substance abuse, where a parent is incarcerated, where a parent may suffer from some mental health issues, it's becoming more common that a third party will come into family court and be able to secure custody rights of a child.
That third party could be a grandparent, a sibling, a foster parent, or
a neighbor who the child was living with because the parent was just not able to do what a parent needed to do.
But even if problem parents do retain joint legal custody, courts are careful where they place the children.
Sometimes it is very important from a child standpoint for one parent to have primary physical custody because a child who does not do well with transitions need a primary custodial parent.
So having possession of the children or having primary possession gives you a lot of power.
For Charlie Sheen and Brooke Mueller and others going through highly contentious custody battles, courts may have to wade through dueling testimony of forensic psychologists, though that may be avoided if legal counsel sets the tone for the best interest of the child.
If a client appears to letting their own emotions get in the way of the best interest of the children, I definitely will direct them because as an officer of the court, I feel that I have my own obligation to protect children.
For the American Law Journal, I'm Gina Passarella.
All right, let's talk to a psychologist and to three attorneys who join me tonight. Don Spry is with us once again. He's been providing family law commentary here on ALJ for 23 years. We're lucky to have him with King Spry, Herman, Freund, and Faul. Dr. Deb Castaldo returns, a psychologist and a family therapist for 25 plus years. She heads the Center for Couples and Family Solutions in Englewood, New Jersey. Mary Vidas is a partner with the internationally renowned Blank Rome law firm. She is the chair-elect of the American Bar Association's Family Law Section. And Frank Cervone also returns, executive director for the Support Center for Child Advocates in Philadelphia. They've been protecting the rights of children and victims of abuse since the 1980s. 1-800-426-4625 is the number right here in the studio. If you want your questions answered, you must call in early. We'll stick around the studio for about 15 minutes after the show to field some of your calls. If you're shy, you can write to us at info@lawjournaltv.com. Okay, let's start with the true and false question. Nowadays, if one person is made to go through a psychological evaluation, opposing counsel will demand the same exam of the other party. True or false?
It's actually false, because if one party wants a psychological evaluation, most psychological evaluators have to evaluate both parents. So I would say that's false. I mean, if one party requested under the rules in Pennsylvania, you can file a petition for a mental health examination, and the court is going to direct it both parties.
So it's automatic in Pennsylvania?
Not necessarily.
If you request one. Well, if you request one.
Some judges will say, I don't need it.
At all?
At all.
Right.
It's discretionary. It is not mandatory.
Okay, but if one person does request it, right. And again, I've talked to three women in the last week who got divorced in the 1990s. Only three, at least in the context of what we're talking about tonight, who talked about getting divorced in the 1990s. And here's what I heard from all three of them. My husband had me psychologically examined. My lawyer didn't have that done. Now the laws may have changed in 20 years, but I guess the simple question is, if that scenario happens today, are we still finding, and especially in courts that used to be sexist, it was the woman who was hysterical, she had the mental problems, the guy was going to get her checked out. I'm just thinking that kind of thing just doesn't happen today, where, again, the court's going to say, well, I want them both examined. But
Well,
you're saying it's hit or miss, if I'm getting this right.
I think you have to make an analysis of whether a custody evaluation is appropriate as a lawyer for your client, because they're not cheap. You're talking thousands of dollars, and as Mary said, some judges, depending on the case, if a judge makes an analysis and concludes that somebody's just doing this to try to be obstreperous, judge could say, I don't need one. Judges don't always put a lot of stock in it.
All right, so if the judge looks at this as maybe this is tactical and not legitimate or organic, then he's going to say, I don't need it. You need a seasoned jurist to make that determination.
Not necessarily a seasoned jurist. A lot of jurists have had family law experience as being their own, representing clients in similar situations. I think the difference between the 90s is if in the 90s, that both parties would go out and get their own psychological expert, and it would be an issue of the battle of one versus the other.
Right.
Most psychological evaluators today are court appointed. Doesn't mean that you can't have somebody come in and do an assessment of whether the evaluation was properly conducted. But most evaluators want to be court appointed, so it protects them and it insulates them from liability from the disgruntled client who doesn't like how the evaluation report may have turned out. The other point is, at the end of the day, the judge is free to ignore or accept the custody evaluator's opinion, because at the end of the day, the judge is the ultimate decision maker regarding what is in the best interest of the children.
Dr. Deb, I've got to think again, you're in the trenches. You may hear it before the lawyers do, and you probably get a sense, if he's going to make me get a psychological evaluation, I'm sure as heck going to make sure that he gets checked out too.
Yeah, I think the problem comes in when it's an escalation of conflict as opposed to real serious, as we're talking about mental health issues, addiction issues, abuse issues. When I see that it's an escalation of the two parties and everyone else involved on their side, so to speak, continuing the battle, then I think it is the right decision to say we don't need this. When there's not very, very clear suspect symptoms of serious diagnoses.
Okay, well, Mary disagreed. I thought we need a seasoned jurist or a judge to maybe be able to see through that, but we at least need a judge who's going to be able to parse whether something is necessary here or someone wants to use this as a tactical advantage. And that does happen, doesn't it?
Absolutely. That's what I'm talking about is it's a tactic more so than that there's real symptoms that need to be evaluated. That's what I'm looking for as a mental health professional. Are there behaviors that are not just part of the marital dynamics that are now continuing throughout the divorce procedures and the fighting and the post-divorce process even? Are they really severe mental health issues that are harmful to children that we need evaluations of both parties?
And Frank, by the time the support center gets involved, this has probably already been more or less adjudicated, because you folks often don't get involved until both parents, at least one or both parents, have been, I don't want to say disqualified, but in a sense no longer represent the best interest of that child.
Well, the courts in Pennsylvania and in most states are not inviting in lawyers for children in most cases, certainly not in most domestic relations custody cases. Most of those cases proceed without a representative for the child. There's a certain trust or whatever we might call it, that the lawyers for the parents and the parents themselves are together going to bring the information to the court that the court needs. Courts look to child advocates, lawyers or guardians ad litem as they're called in various places. They look to lawyers for the kids to bring information forward, and in Pennsylvania to ensure that the child's voice is heard, the child's understanding of where this case is going, of who they want to live with, of who they want to spend time with.
And you can be called in even if the court does award physical custody or joint legal custody to either or both parents.
Yeah, as you were suggesting, in the domestic relations case, as compared with a child welfare case, for example, where there's some allegation of abuse and neglect, where the government has come in as a kind of third wheel into this proceeding, into this family life. The children's lawyer is going to help the court make a determination of what's right for that child.
Okay, I've got another true or false question. Let's see if I do a little bit better this time. I got a little bit of pushback from the attorneys on the set. Okay, man is abusive, not physically so. Woman, wife, has been diagnosed as bipolar. Both want custody of the kids. True or false? Woman, in this instance, has less chance to get custody than the husband.
False.
Okay, I'm over 2. Go ahead, Mary.
Right.
Tell me why.
I can't tell you the number of people in the United States who have been diagnosed as bipolar.
I know,
but bipolar
there's still
doesn't,
that stigma, though.
But it doesn't necessarily. The stigma, there is a stigma. The stigma can be overcome. The question is whether that bipolar parent is on medication, whether that bipolar parent is still the best parent that provides the nurturing, the structure, the consistency for a child. Just because the parent is bipolar doesn't necessarily preclude them from being granted either primary custody or shared physical custody.
And let's hope so. Go ahead, Don.
Well, I was going to say, it's similar, I think, to alcoholism or any other issue. What courts are interested in is having the children have a relationship with both parents. So they're going to look to, are the parents controlling it? Are they handling it? Is that behavior going to affect the child? I've had situations where people have had alcohol issues, and they've gone to AA, they've dealt with it. Judges look at that, as opposed to somebody that's not dealing with it. I think that's the most important thing.
I understand that, but let's say a person comes into you and they want to hire you to represent them in a custody matter. You've got to know whether or not that soon-to-be ex-spouse of theirs has a history of any kind of mental illness. And today, again, as Mary was alluding to, that has expanded so widely.
Sure.
Generation ago, suicidal, homicidal, maybe schizophrenic. Today, every permutation of depression, bipolar 1, bipolar 2, that sort of thing. But you've got to know about that as an attorney, don't you?
Yes, you do have to know about it to know how to deal with it and how your client's dealing with it, because I think a judge is going to probe that. But just because someone has a mental health issue, I don't think automatically means that they're not going to be able to have custody or expanded partial custody.
Right, and that goes to your point.
I agree with Don.
Right, and again, and hopefully courts have become a little bit more open to mental illness, depression, et cetera. And again, in the 1990s, bipolar diagnoses went up by 4,000%. Some say that was the pharmaceutical companies. Some say we have better ways of detecting these kind of mental illnesses. So.
Chris,
go ahead, Frank.
You heard from both Mary and Don, I think the right perspective in the contemporary age, and it's asking from the child's perspective, in a sense, from a child-centered approach. What is the effect of that mental illness, even of that substance abuse? What's that effect on the caregiving? What's that effect on the ability of this parent to provide the care and nurturance that the child needs? Those are the questions that the courts are asking.
And
in fact,
Frank,
under
do you think
Pennsylvania law, they're required to ask.
Okay, do you think that courts are able to handle, are they equipped to handle this kind of information?
Not to disparage the qualifications of our jurists, but the numbers of cases and the complexity of the cases is fairly overwhelming. In big jurisdictions, in Pennsylvania, in Allegheny County, in Philadelphia County, there are literally tens of thousands of cases before the court, and most of those cases, in excess of 75%, don't have a custody evaluation at all. So not only is the court ill-equipped, the court is not given the resource or tool to make that judgment. Now we're talking a little bit like a crystal ball. That's a rough place to be.
Yeah, I agree with Frank. The problem is that in cases where the parents economically can't afford a custody evaluation, as Don said, could potentially cost thousands of dollars. Most custody evaluations are going to take at least 6 months, because most evaluators following the American Psychological Association guidelines know that when you go through an evaluation, you're putting your best foot forward. So they want to see the parents over time, how they react to different situations. You're in Philadelphia and a client comes in, and whether it's mental illness, alcohol, or drug addiction, they're sending you over to 1801 Vine or to the new courthouse of 15th and Arch to have a drug assessment, a drug test, to have a quick assessment psychologically. Those assessments take 45 minutes. Are they really giving the court a look inside? No, but they're giving the court something. And that's the problem with clients who can't afford it. They're giving quick shrift. They're saying, fine, you're going to go over and have a blood test, an alcohol test. You're going to have an assessment to make sure you're not a danger to yourself or others.
Sure.
But it's not the same thing as a custody evaluation.
And Dr. Deb, do you find that sometimes is a chilling effect? There is a chilling effect on people who just can't put up the money to sit down and talk to someone like yourself.
Well, absolutely, because then they're restricted, they become kind of paralyzed, and they have no leverage sometimes to protect the children when it is a serious issue of dysfunction of one of these types. The other aspect is when it's borderline situations. I get really concerned about that, where the level of dysfunction is harmful to the children. It may not be enough to report it to child welfare authorities. They may not have the money to get a full evaluation, and especially in a lot of cases of women who their income has gone down because they've separated and maybe child support is not being paid. And now they have really very little leverage to empower themselves to deal with addressing some of these issues.
And I thought what you said was interesting. And again, I think today, because of the expansion of what we call as a mental illness or depression, there's this greater permutation. You probably are dealing with some issues which are kind of on the bubble, where someone might be maybe sociopathic or the kind of person who says, I love you, don't leave me. And that person is not going to be diagnosed as a schizophrenic, but they are a danger, maybe to themselves, certainly to the ex, possibly to the kids as well. And someone's got to take some action. Otherwise, the best interest of the child is not going to be served.
And yet, these are some of the cases that fall through the cracks. They can be doing very dysfunctional things, and yet if it doesn't fall under that criteria, if a really great psychiatrist or psychologist does a full evaluation and they don't come up with one of the more serious diagnoses, that person can still be dysfunctioning in a very harmful way to the children and yet not have a diagnosis, as opposed to, I think when it's a clear case of this person has a full-blown, untreated, one of the more serious diagnoses, one of the axes of mental health conditions that we can clearly say this is really a prohibitive condition that's not being treated, then it's a lot easier to make recommendations. I think it's these fuzzy situations that are hard.
And we have more of those fuzzy situations today. Let's get to some of your telephone calls and emails. Again, the number is 1-800-426, there it is, 4625, 1-800-426-4625. Let's go to Sandy, who's up first tonight. Sandy, what's the question you've got for our panel?
Hi, yes. My son gained custody of my grandchild when the mother moved away a few years ago. She has since moved back and has asked for visitation. So for the past 2 years, we've been having issues when she has her either belittling our family or cursing at the child, or it's just not a healthy environment. And the mother actually is bipolar, and so is the grandchild. And we have had her in counseling for years, and the counselors feel that she is just feeling abandoned every time because the mother does not do the visitations that she asks for. She may see her 1 week and then not see her for 2 months and have no contact.
Sandy, I'm going to ask you a question. Sandy, I don't know if you can hear me. I'm going to ask you a question. You may not have the answer to it. Do you know if that assessment, that bipolar assessment, was put in the order when custody was granted to your son some years ago?
No, because we had her since she was 4 years old, and she would act out, and we took her ourselves, and we had her evaluated, and she was put on medication.
What does that say? Go ahead, Frank.
Frank
Cervone's got a comment here.
The first flag I'd want to raise is even the question of a diagnosis of a young child with bipolar tendencies or a bipolar disorder. That's a very suspect place to go in children's mental illness. The mother's mental illness is certainly another story, though bipolar, and Dr. Deb can talk about this. Bipolar is itself very difficult to diagnose, tough to engage, tough to treat, all the way around. Those situations make for hard cases. you take it back to where we were a moment ago in terms of evaluation and what the effect is on the child. It's probably some combination of the mother's mental illness and her overall kind of instability in schedule. It's the simple reality that she's not keeping the schedule that she committed to with this child that's having as much an effect as anything else. The child gets excited perhaps, gets to expect to see her mom, and mom doesn't show.
So, you know, Frank, in some ways, I know it's a legal problem, it's a legal issue, but it's probably more an emotional, familial, best interest of the child outside of the pure, let's say, dryly logical legal interpretation here.
That's right. On the one hand, and in this story, we haven't, you know, we've heard some issues of instability. We haven't heard anything yet from the caller whether the situation has gotten more abusive to the child in a way that it's in a sense deeply, profoundly impacting the child. Because we know as well, at some level, I'm betting this little girl wants to see her mom. She probably, you got to figure she misses her mom, and we have to speak to that experience of the child as well.
How do you deal with this legally and not just knee-jerk back into court, back into legal process?
Well, the problem is the courts can't deal with situations like this real effectively because, you know, it's like the client who comes in and says, I want her, I want him to have a relationship with the child, but it's got to be on my terms. I mean, I agree with Frank that this little girl probably is reacting out, emotionally upset because her mother isn't adhering to a schedule. I can't tell you how many clients have said, why can't we force her to take custody? The answer is we can give you custody, the court can award you custody, but they can't force a parent to be a good parent unless, you know, the courts aren't going to get in. I've had clients say to me with special needs children, I need a vacation. Can you get them to take 2 weeks in the summer so I can go off? And the answer is, you know, some judges might do it, most judges won't. Because they're more concerned with making sure there's a custody order that's complied with, but they're not going to be there to deal with the minutia of somebody's life who doesn't show up for a 2-hour visit.
Don,
and that's a little bit of a frustration sometimes when you represent, you know, a court, if it goes on long enough, will enter a contempt order if a custodial parent doesn't provide partial custody to the other parent, but the other parent that doesn't show up is also technically in contempt, but you don't get it going both ways.
So any pragmatic advice you can give Sandy tonight?
You know, I don't know whether an alteration of the custody schedule or the partial custody schedule makes sense, but that you don't want to keep the child away from the other parent.
Well, and I'm also going to cheerlead for my profession. I think in cases of these situations where maybe, you know, with the court backlog and all the cases, family therapy is so critical, where we do mediating and really trying to pull in all family members in different combinations to solve some of these things so that they don't have to go to court.
Good luck, Sandy. Let's go to an email question next. This comes from T.E. in Woodbury, New Jersey. My wife is an alcoholic. Sometimes she's violent. Sometimes she just passes out. We have 2 kids together. Can I request supervised visitation? If she gets unsupervised visitation, can the courts order her to stop drinking or at least stop drinking around the kids? There's a good degree of innocence.
I'm happy to answer that question because I see that a lot. Yeah. And the answer for the gentleman in Woodbury is absolutely. And there are the courts are becoming much more aware. Technology has improved so much, whether it's a SoberLink monitoring device that can be put on a car so that the person can't even start. They have to blow into a breathalyzer before the car will turn on. Whether they, I've had cases where the children have come home from school and the mom has been passed out in the basement with a bottle of vodka, or the mom is picking up the children drunk, driving them home from school, and has to get out of the car to go to the bathroom in the middle of the street because she's drunk. And these situations, alcoholism is a horrific disease that impacts children to such an extent negatively. So I would say to this gentleman, yes, the court can order no alcohol or drugs around the children. How do they supervise it? A lot depends on the age of the children. But if the children are of school age, they're going to be able to identify when their mom isn't acting right. But yes, the court can certainly order that and should order that.
Let's go to Jennifer next from Philadelphia. Go ahead, Jennifer. What's your question? Jennifer, you're on the air. Is Jennifer there?
Hi.
Go ahead.
Can you hear me?
Yes, we can. Go ahead.
Okay. I'm in the middle of a divorce. My husband's been abusive. I'm pretty sure he's got a mental disorder. And my question is, I'm trying to get full custody. I'm pretty sure that I'm going to get it based on everything that's happened. But I want to know, does his parents have any rights towards my kids? I really kind of want to cut them all out, him and his parents, just out of my life as much as possible. Not necessarily out of kids, but how much do I have to let them in?
Well, question, Don. Go ahead.
I'm happy to. Don, I'll answer it. I mean, the fact is she's going to have a hard road to hoe.
Yeah.
That children need a relationship with a parent, good, bad, or ugly. And that's why, to the extent, I don't know what the abuse is. She just said he was abusive. Whether it's mentally or sexual, that's a whole different opening a can of worms. But the ability to, first of all, custody in Pennsylvania is always modifiable. You do not need a change in circumstances. So if I were advising that father and this was the situation, I would be having him deal with a therapist, a parent, co-parenting, getting him back on the track, giving him the things that he needs to do to improve his relationship with his children. And if it does, I unfortunately for this lady, I don't see her getting sole custody, that the children are not going to have a relationship with their father.
Go ahead, Don, quickly, if you will.
I think I agree. Sometimes you can get supervised partial custody or visitation if the facts warrant it, but that's difficult. In my experience, it's difficult to get that unless there's some real conduct that causes harm to the children.
Folks, we want to remind you we are still here in the studio. We're going to still take your telephone calls once we leave the air. At 7:30, 1-800-426-4625 is the number right here in the studio, or email us at info@lawjournaltv.com. It goes quickly. I want to thank Don Spry with King Spry, Herman, Freund, and Faul, Dr. Debra Castaldo, the author of Relationship Reboot, and the therapist and psychologist who heads up the Center for Couples and Family Solutions in Englewood, New Jersey, Mary Vidas with Blank Rome in Center City, Philadelphia, and Frank Cervone, Executive Director for the Support Center for Child Advocates in Philadelphia. For all of us here at the American Law Journal, thanks for joining us this week. Until next Monday night, case closed.
This week's American Law Journal has been made possible in part by Law Catalyst, legal media and marketing for lawyers. Go to lawcatalyst.com. Beatty, Sloan, and DeGeneva, personal attention for those hurt at work or suffering from serious injury. King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Scheller PC, protecting consumer rights since 1977. Blank Rome, providing strategic advice for employers in today's workplace. And The Legal Intelligencer, an American lawyer media company, and the oldest daily legal newspaper in the United States.